I want to talk to you about the fork in the road. What do you do when you get that ROI and that notice of rights? Let's talk about the pros and the cons so you can be better prepared to place yourself in the best position to prevail. Now, the agency has to complete its investigation, and so and this is for federal sector employment discrimination. So if you're watching this video, you probably understand because you probably already have reached that crossroads where you are given the choice, to go with a federal hearing or go with a final agency decision or file a civil action. And this comes when you receive a report of investigation. Otherwise, I'm going to refer to it as the ROI. It's known as the EEO ROI. It's the report of investigation. It does not make any findings or conclusions. Okay? It provides you with a notice of rights. And that is what the rest of this video is about. It gives you deadlines to choose. Okay, I'm not going to get into the nitty-gritty of the deadlines because those are governed by regulation. Regulations change. You just need to know that it gives you deadlines to choose these routes that I'm going to talk about. The EEOC hearing route is the #1 most common way that we go. That is where you get to choose to have a hearing before an administrative judge. Okay, now there are a lot of benefits and there are a lot of pros, a lot of cons. I'm going to talk about the pros. I love how this preserves your other rights. So this preserves your other rights. You can choose this route, and if you change your mind, you can always choose to have a civil action in federal court, or you can always choose to motion for a final agency decision and go that route. So the other routes that you're presented with when you receive your ROI, those routes are preserved if you choose to go the EEOC hearing route, because if you change your mind. And it's a unique system for federal sector employees. The EEOC has administrative judges. They adjudicate your case. You get your day in court. And so it's a very unique system for federal sector employees, and that's a very good pro because even if you lose at this level, you can always later go to federal court if you choose to. The evidence rules are also more lenient in terms of hearsay being allowable. There is a lot of affidavit testimony and things of that nature. Settlement opportunities are awesome within the EEOC hearing route system because the judges get very involved in settlement. They sometimes force you to go to settlement conferences with other settlement judges. They have good mediation programs. So settlement, there are opportunities to settle when you go this route. Additionally, it's private. This is not open to the public unless you appeal your case to the EEOC. And even then, you're given a pseudonym. But it's a very private process. And you have a wider choice of specialized representation. So you can seek somebody nationwide, such as myself, who specializes in this because the regulations allow for nationwide representation in this field. You can also amend your claims at this level. So if the agency did not frame your claims properly, you can go ahead and get this done with a judge. So there's a chance to amend or consolidate cases and claims if that's advisable. The con, this is one of the biggest cons. It is long wait times. This is a very slow process. Just because you request a hearing does not mean you are going to have a hearing right away. It could take up to a year or longer for an administrative judge just to be assigned to your case and get the process started. This is very difficult to do without representation. This is the part in a case where you really should get representation if you're going to go this route because it is litigation. It may be more lenient when it comes to evidence rules and things of that nature, but procedurally, and everybody, all of the players are attorneys. The judge is an attorney. The agency's counsel is an attorney. And then there's summary judgments. You may not have your day in court because a motion for summary judgment could be filed either by the agency or by the judge. And they could dismiss your case or decide it in favor of the agency without you having your day in court. Once things get started, it could be very time-consuming litigation. So on the one hand, there could be very long wait times where there's no action. And then things get started with an order from the judge, and there's very time consuming with depositions and things of that nature. And then there of course are costs. Just like with any litigation, there are going to be costs. We offer affordable representation, but even with that being the case, there are always costs. The final agency decision choice. So you do have a choice to request a final agency decision, where the agency will decide whether or not they discriminated against you. You can already kind of tell where that's going to go sometimes. But the pro is that it could be cost effective in the short term, and the final agency decision, could conceivably be in your favor, although that is very rare, and for reasons I will talk about shortly here. You can appeal the FAD to the EEOC or the OFO, Office of Federal Operations, so it can be a very good stepping stone just to get to an appeal to a neutral decision from the EEOC, Office of Federal Operations in Washington, D.C. And you can file a civil action. And in fact, the final agency decision will give you your notice that says you can file a civil action in federal district court. Regulations say that. So this could be a way to get to federal court, and you can learn the agency's position before you go to federal court. So the cons, of course, these are biased decisions. Although it is a different place within the agency, a different section that will decide the final agency decision, it is still ultimately the agency deciding whether it discriminated, and so it's going to be biased. It's not neutral. It's usually no more than a stepping stone for other routes. So if you want to get to the appeal quicker, if you want to get to federal court and you've already decided to go those routes, it may be advisable to go ahead and request the FAD so you can see the agency's position and then go for those other routes. You can also, you need to understand that this waives your right to an EEOC hearing. So unlike when you choose an EEOC hearing where that does not waive your right to a FAD, the reverse isn't true. If you choose a FAD, you give up your right to an EEOC hearing forever. You still have a right to a civil action in federal court, but you waive your right to an EEOC hearing if you choose the FAD route. So just be very mindful of that. And also, it's somewhat limited to the ROI record. There are always exceptions, but the final agency decision is being decided on the record, and any appeal you do from that to the EEOC, Office of Federal Operations, is going to be limited to the record as well. That's generally the rule. And of course, another option is always the civil action in federal court. This option generally follows you around. So even if you choose options 1 or 2, you can always keep this option up your sleeve. One of the pros of this option is that you engage in faster litigation. You get your day in court much faster once you file your complaint. And it's governed by rules that govern the timelines of everything. So you're litigating in federal court, and things tend to move a little bit faster. Another pro is that it's public. Now, again, to each his own. If a public type of lawsuit is favorable to you, then this can be a pro. So whereas the EEOC process is private, this right here is public, and there's more accountability, especially if there is some very damning evidence in your favor. It can probably increase your settlement leverage. And of course, there is the possibility of a jury trial. I say a possibility because you might not make it that far, and we'll get into why. But there's the summary judgment option. There's also the settlement option. But what I love about federal court is that you could get a jury trial, a jury of your peers. And of course, for those who are struggling financially, a court-appointed attorney is possible. You could apply to get a court-appointed attorney, and so that's a very unique thing in civil in a civil action, and that is a possibility. You would have to apply and qualify though for that benefit. So those are some of the pros. Of course, the con is that it is very costly. You have to pay filing fees, and you're going to have to pay for attorney fees unless you work out some kind of agreement. But generally, there's going to be a lot of costs. And even if you do a contingency agreement, there's going to be costs that are going to be recouped on the back end. And many attorneys may not take a case because of the cost. The rules are much stricter. So hearsay and things of that nature need to abide by the rules. Rules of evidence, there are the federal rules of evidence, federal rules of civil procedure, and then each federal district court also has local rules. They have local rules that correspond to these federal rules, and then there are the judge's orders, and so everything is very rule driven, and then the electronic filing system also has its own set of rules. So it is very difficult to do without representation. Doing the EEOC hearing is difficult to do without representation. This right here would be very difficult. I think it would be case suicide to try to navigate these waters without representation. And once you get that litigation going, it is very time consuming. Just like an EEOC hearing, litigation would be very time consuming. And then there is a high probability for summary judgments being filed. And most statistics work out in favor of employers. So a lot of cases are disposed of on summary judgment against the employees. And even though it is much faster, I believe, in federal court, in my opinion and experience, there can still be long waits. There could still be some limbo periods. Perhaps not as long as the EEOC in general, but there could still be waits. So what is a recap of maybe the highlights of the benefits? Option number one, the EEOC hearing preserves your other routes, and it gives you your possible day in court eventually. So it's possible you're going to have your day in court, but and then it'll happen eventually, meaning that there are very long waits. So with option number two, remember, a FAD could be faster and more cost effective, but maybe a little bit more, maybe little more than just a procedural stepping stone. A civil action is generally a faster litigation, but it is more costly, more strict, more time consuming, and more risky. So these are the considerations that are general that you should think about and have a talk with your attorney. If I'm sending you this and you're my client, have a talk with me if you have any further questions about this. because which route is the best is a case-by-case scenario, but hopefully this is giving you a solid foundation